Is a prenuptial agreement stronger than a will? Well, they're actually different things, and they have different rights, and they control different dynamics of wealth transfer if you were to pass away. A prenuptial agreement is merely an agreement between two potential spouses as to the rights that they have for each other. And so it's meant to modify what the state law would otherwise allow as default inheritance or divorce rights. In the event that something happens, either the divorce or the death of a spouse, it's setting forth what the other spouse is entitled to or what rights that they may petition for. A will is meant to dispose of assets or direct certain things to go to certain heirs if you pass away. Sometimes a will can embrace a prenuptial agreement, or it can be impacted by a prenuptial agreement. But the prenuptial agreement is setting forth beneficial rights of a potential spouse. That generally impacts the way that we would draft a will or a trust or any sort of estate planning strategy for spouses with a prenup in place. But generally, if a spouse has waived inheritance rights and then a will gives that spouse an interest in the estate of the deceased spouse, the will is still going to control, because generally what a prenup says is you don't have the right to elect more than what I give you, but I still have the right to give you whatever I want. And so often prenuptial agreements are a component or a layer of an overall comprehensive estate planning strategy. It just allows us to have a very intentional outcome as to how we can create an estate plan to benefit each other.